hearing has 5 distinct sub-issues, being A, whether the petitioner was afforded sufficient opportunity to present her case, B, whether the senators were given adequate time and opportunity to consider the matter, C, what is the probative value of the statements both during and after the fact by a section of the senators, so it should be 6. D, whether there were disruptions or disorder of a nature as to deny the petitioner a fair hearing. E, whether in the Senate proceedings the petitioner was subjected to discriminatory or unfair treatment. And F, whether there is evidence that there was a preconceived outcome and thus the hearing before the Senate was a sham. The question of whether the petitioner was afforded a sufficient opportunity to present her case requires an examination of both the individual milestones in the hearing process as well as an overall view of the entire Senate process. In both aspects, the petitioner has provided evidence in the form of the Hansard that shows that the procedural milestones were met and they were of a sufficiently proper nature as to insulate them from an adverse finding by this court. The petitioner may disagree with the overall outcome of those steps and how they connected as a whole, but the petitioner has not shown a deficiency in each or in all as a collective that would require this court's interference. Another aspect of the petitioner's argument is that she was only given 2 minutes to make a personal statement at the conclusion of the proceedings and that she did not get the chance to deliver it. However, the court's review of the Hansard and video recordings indicates that the Speaker of the Senate granted her the opportunity to speak. The uncertainty regarding whether she remained silent by choice or whether there was a technical issue with her microphone does not alter the fact that she was given the opportunity to address the Senate. Moreover, her legal counsel did not raise any objections during the proceedings, either regarding the time allocation or any technical difficulties. Courts have previously held that a party who fails to object to a procedural issue at the appropriate stage cannot later claim to have been denied a fair hearing. In Republic versus Public Procurement Administrative Review Board and another ex parte Gib Africa Limited and another 2012, the court ruled that a party who fails to raise an objection at the appropriate stage of proceedings cannot later claim to have been denied a fair hearing. Since the petitioner did not object at the time, and there is no evidence that she was prevented from speaking, the claim that her right to a personal statement was violated lacks merit. Similarly, the petitioner has failed to show that the senators did not have sufficient time and opportunity to consider the matter. The respondents and the interested parties who oppose the amended petition are correct in stating that it is not for this court to impose its own view on how much time should have been allocated or how the matters should have been laid before the senators, but rather to see if they meet the basic requirements of a fair hearing. I note that the impugned resolution process commenced substantively with the Senate's decision not to have a special committee hear the matter and prepare a report which would be voted on by the House, excuse me, but rather have the entire Senate sit as a committee of the whole House and vote as the special constitutional procedures applicable require. This, to my mind, meant that each senator who participated had sufficient time and opportunity to consider the matter. One of the petitioner's key complaints is that senators were only allocated 3 minutes each to debate the impeachment motion, which he argues was an insufficient amount of time. The petitioner has presented signing-in forms suggesting that some of the senators may have objected to the short debate time, as well as statements made thereafter about an alleged admission of insufficient time and opportunity by some of the senators. However, for such an argument to hold legal weight, the petitioner should have ensured that the senators who felt constrained by the debate time had sworn affidavits confirming that they were unable to effectively express their views and consider the matter and file them in these proceedings. Courts have consistently held that procedural fairness should be analyzed holistically rather than focusing on isolated aspects of a process. In JSC versus Mbalu Mutava and another 2015, the Court of Appeal emphasized this point. Applying this principle, this court finds that negatively impacted the fairness of the hearing. Courts have previously ruled that not every procedural irregularity renders a process unfair. Only those that materially affect the fairness of the proceedings are considered grounds for judicial intervention. In Dry Associates Limited versus Capital Markets Authority and another, 2012, the court held that not every procedural irregularity is fatal. Only those that cause substantial prejudice to a party's rights will justify the setting aside of a decision. In this case, the court has determined that while the proceedings may have been politically charged, there was no significant disruption that prevented the petitioner from presenting her case effectively. Therefore, the argument that procedural chaos rendered the hearing unfair is not supported by sufficient evidence. On the penultimate sub-issue, the question of gender discrimination and denial of equal treatment under the law, there can be no denying that, zooming out from the present case, we remain a nation that regrettably has not made the strides towards gender equality and promotion of the participation of women in governance that a nation of our democratic credentials should have made. There can be no denying the fact that despite all our other successes in constitutional implementation and deepening our democracy, the area of fostering inclusivity and diversity in political representation remains one in which we need to do much better as a country. It is difficult for women to successfully demonstrate gender bias and denial of equal protection of the law in the governance arena, because more often than not, these biases and discriminatory treatments are not brought out starkly by those who perpetrate them, but rather they are subtle, yet significant actions, decisions, and omissions that create an unequal playing field for women. That being said, the petitioner and the second interested party have not particularized this complaint with specific reference to the Senate's proceedings, or shown an aspect or element of the proceedings before the Senate that show gender bias against the petitioner. Perhaps this is because, while we have a wider problem with gender bias, the Senate conducted its proceedings strictly without any form of gender bias against the petitioner. Had the contrary been demonstrated to the required standard, then on this sub-issue of 7 main issues, this court would have had no hesitation in quashing the Senate's resolution. The final claims raised by the petitioner relate to the dating of the Gazette notice and the clerk of the Senate's letter, as well as the speed with which the Senate conducted the impeachment vote. The Senate contends that the Gazette notice and the clerk's letter were both dated 20th August 2024, despite the vote taking place on 21st August 2024, which she argues is a proof of a predetermined decision. Under Section 107 of the Evidence Act, the burden of proof is on the petitioner to establish that these documents indicate a premeditated decision rather than being the result of a typographical or clerical error or even a good faith mistake. The petitioner failed to provide evidence to refute the simpler explanation that the date discrepancy was a minor administrative oversight rather than the much more serious claim of a proof of a rigged or predetermined process. Similarly, the claim that the Senate rushed to conclude the impeachment or sat on non-gazetted days has not met the required threshold, as there is no requirement that the impeachment proceedings must last a specific duration. Courts have previously held that the expedited process is not inherently unconstitutional unless it is demonstrated that it deprived a party of an opportunity to be heard. In Republic versus Speaker of Nairobi City County Assembly and another ex parte Evans Kidero, 2017, the court held that an expedited process is not inherently unconstitutional unless it is shown that it deprived a party of an opportunity to be heard. The petitioner has not demonstrated how the Senate's action of expediting the hearing and determination of the matter before it deprived her of an opportunity to be heard or was indicative of a preconceived outcome. An analysis of all the applicable evidence demonstrates that the petitioner was accorded all the procedural safeguards necessary for a fair hearing, including the opportunity to present evidence, respond to both allegations as well as questions from the senators, oppose the county assembly's position, and make a final statement. Excuse me. The Senate proceedings followed standard parliamentary procedure, incorporating an opening statement, presentation of evidence, an opportunity for senators to ask questions, and a closing statement. The court has assessed the totality of the impeachment process and found that the petitioner was given ample opportunity to present her case and respond to allegations leveled against her. While the petitioner has pointed out certain aspects of the proceedings that she considers unfair, such as limited debate time, the opportunity to make a personal statement, the alleged chaotic nature of the proceedings, the timing of official communications, and the perceived haste in concluding the impeachment, none of these claims have been substantiated sufficiently to warrant a finding that her fair hearing rights were violated. Therefore, the Senate's impeachment process was procedurally sound and does not warrant judicial intervention on grounds of unfair hearing. Conclusion. Paragraph 133. Gubernatorial impeachment is an invaluable safeguard against impunity and abuse of office that must be jealously protected. It must not be allowed to become an avenue for fighting political proxy wars or resurrecting the ballot box contestations that were determined by the electorate when it chose a particular candidate to hold the office of governor. In that regard, the Senate, as a national legislative body that is able to rise above the din of the county-level gladiatorial arena, is uniquely placed to safeguard the sanctity, probity, and vitality of this very important accountability measure. Watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. Interventions by the courts come further down the impeachment path, and thus it is the duty of the primary duty bearers, the concerned county assembly and thereafter the Senate, to ensure that impeachment remains as constitutionally envisaged. Turning back to the present case, and in light of the foregoing, the inescapable conclusion is that the amended petition dated 23rd December 2024 has not met the required legal threshold for success. As outlined above, certain aspects of what was laid before this court and submitted on extensively by the parties has been reserved for determination in another forum, a situation occasioned by the petitioner's choice to split her grievances into two petitions pending before two different high court stations. What this court could safely determine without falling into sub judice was insufficiently articulated for finding in favor of the petitioner. While ordinarily course would follow the event, in the circumstances of this matter, I am satisfied that it is fit, just, and proper that each party bears its own costs. Before I rest my quill by penning the disposition and final orders, I must thank the learned counsel for the parties in this matter for their industry, adherence to strict and short timelines, and the professional courtesy they extended each other. The breadth of their written submissions and the manner in which they ably highlighted those submissions orally made this court's task of judgment writing a lot easier. I would also like to thank the parties for maintaining decorum while attending court sessions, despite this being a highly emotive and charged matter. Disposition and final orders. Consequently, and for the following reasons, this court finds and determines that A. The amended petition dated 23rd December 2024, which is the subject of the proceedings herein, is found to be without merit and is dismissed accordingly. B. The Gazette Notice number 10351, volume CXXV1, number 130, dated 20th August, published on 21st August 2024, and issued by the respondent communicating the decision and/or resolution of the Senate to remove the petitioner from office as the governor of Meru County by way of impeachment is affirmed for the purposes of these proceedings. C. Consequent to A and B above, the subsequent constitutional and statutory actions are free to take place as per the applicable timelines. And D. Each party shall bear their own costs. Dated, signed, and delivered in open court on this 14th day of March, 2025. I did, before Councillor Mutuma, before you speak, I did state at the beginning that I would give you hard copies. As I was reading through, I saw one or two spelling mistakes, little double words. I will work on those. It will be uploaded into CTS. You'll have it today. So I'll do that. You'll have it on CTS today. I have signed the hard copy as required by the law with my handwritten corrections of those spelling mistakes. Yes, Councillor Mutuma?
Yes, thank you, Your Lordship, for the judgment. We note the expeditious nature in which the court has been able to dispose of this matter.
Yes.
My instructions, Your Lordship, is that we note from your judgment that a majority of the issues raised in the petition remain unresolved.
Yes.
And have been shelved and reserved for determination by the petition pending in Meru.
Yes.
We are therefore of a strong position that there is need to grant the petitioner an opportunity to have those issues which are the majority heard and determined.
Yes.
And since the court has had the opportunity to hear the issues being canvassed by all parties extensively,
Yes.
it will then appreciate the need for the issues, for the very weighty issues, to be determined.
Yes.
As such, Your Lordship, my instructions are to humbly request you to grant us temporary relief in whatever nature, but specifically an order of status quo to be maintained in the prevailing period, A, to allow the petitioner ably prosecute the issues pending before the Meru Court, and secondly, to also consider exercising a right of appeal in the Court of Appeal.
Yes.
This order of status quo, Your Lordship, can be structured in such a manner that it will be time-bound with the effect of automatically lapsing should the petitioner not have gotten a relief either from the Meru Court or from the Court of Appeal. We submit, Your Lordship, that there will be absolutely no prejudice on any of the parties if orders of status quo are maintained. In any case, it is the situation that has been prevailing since August 2024. Having that situation maintained for the next few weeks or months will not in any way prejudice the petitioners
Just a moment, please repeat the period.
The period, my submission to your lordship is that in any case, the status quo has been prevailing since August 2024. There would be no prejudice if that same situation is maintained in the next few weeks, or rather for the next few weeks or months, just to ensure that the very weighty issues that the court has appreciated will have an opportunity to be determined on merit. The contrary is true, Your Lordship, that should an order of status quo not be issued, then effectively, whatever is pending in Meru, whatever is pending in the Court of Appeal, like the court has ably noted, is all rendered an academic exercise. By dint of Article 23, we humbly request the court to issue conservatory orders post-judgment. And to expedite our next move, Your Lordship, we humbly then request the court to direct the Deputy Registrar to supply us with typed proceedings in this matter. And a copy of a certified judgment. That is all, Your Lordship.
Yes, thank you, my Lord. My Lord, we oppose the application for the first reason that this court has identified.
You oppose?
Yes, we oppose the application. My Lord, in the judgment, this court has identified that the petitioner's action of approaching two different courts was for this purpose exactly. This application is meant to dismiss the respondents from enjoying the fruits of the judgments after this court has started and had parties on merit. I know it is not true that there will be no prejudice. The court has found that on merit, the Senate did conduct a proper process within the law.
Yes.
And further suspending that process is not in the interest of justice. It is not in the interest of Article 10. And it is not what is envisaged under Article 181.
Yes.
My Lord, the petitioner having been found to be worthy of living office pursuant to Article 181. She has remedies in other courts, but at this point, this court is found insufficient. My Lord, the Meru Court is seized of the matters pending before it, and you have rightly declined to deal with those matters. That court can make appropriate orders concerning this issue. That court can quash any process. They have the power to do that based on the material before them, which is not before you this afternoon. My Lord, in the Wajir impeachment case, the court quashed the impeachment and the process proceeded after that. But for this court to be asked to take action based on the matters before the court in Meru is not proper, and it is negating the judgment delivered this morning and further suspending a proper decision of the Senate. My Lord, we oppose. Thank you.
Just a moment. So we have quite a number of interested parties. So I will call on one from each side. First interested party, Councillor Lawi.
Thank you, Malone.
Yes.
We should thank you for the industry that the court has shown in determining this dispute within the timelines that it has slowed down. Malone, we wish to submit to associate ourselves with the application by the petition. With regards to the request for a status quo order, this will enable the parties to ventilate the issues that the court has so referred to the petition that filed in mail.
Yes.
And these interim orders will be able to avoid the disruption of the governance. We also wish to request for time copy of the proceedings as well as certified copies of time. That is all I'm saying.
Councillor Kirimi.
Thank you, my lord. On behalf of the interested parties who opposed the petition, my lord, first and foremost, to thank you for the good judgment that you've delivered. And my lord, on behalf of all my colleagues who appeared before you, and as the senior most counsel perhaps who appeared before you, we are sincerely grateful for the opportunity to canvass the issues we did before you. My lord, so that I won't come again before you,
Yes.
we are also sincerely grateful to yourself for the professional courtesy that you extended to us.
Yes.
My lord, in a specific way, we are very grateful that you found in your heart to forgive us when we did not appear to be proper before you.
Yes.
And we thank you specifically for pushing yourself and ourselves to meet the strict timelines that you set to canvass this petition before you. My lord, turning to the application by Mr. Mutuma, we do oppose the same.
Yes.
First, you are now franked as official. Secondly, my lord, the weighty issues Mr. Mutuma is raising from the bar cannot be raised in an oral application. We would kindly suggest that the petitioner finds it proper to file a formal application before you for urgent consideration and for a formal opportunity to all parties opposed here to file a response. Thirdly, Your Lordship, by making any decision that will amount to a stay of the negative orders you just granted, with all due respect, Your Lordship, you will be sitting on an appeal of your own decision. And my Lord, this court will be making its orders appear inferior to orders of other courts. We urge Your Lordship not to be persuaded at all to grant any orders of status quo. Fourthly,
Yes.
there is grave injustice and prejudice that is going to be suffered by the people of Meru and the voters of whom I represent by an order of status quo or stay or an umpteenth time applied for conservatory order. My Lord, that will be in breach of Article 10 and Article 1 of our Constitution. My Lord, fifthly, we are alive that the petitioner has a right to appeal against the decision. The superior courts may grant orders of stay if the property says to have that legal mandate. But your Lord, as far as you're concerned, you've done your work. We kindly ask you not to allow a stay of that decision, even for a second. People have never been waiting for this judgment. The court has rendered itself. It's upon all of us as parties to take up our other rights, and the constitutional frameworks and set standards should now take effect. We are established.
Thank you. So give me about 5 minutes to write. Yes.
The amount is not inside. I beg for 5 minutes.
Because we have so many interested parties, if I extend to yourselves, for fairness, I'd have to extend to others. It's a straightforward issue. I think every counsel who walks into a court in this country and beyond has an application for stay in their mind, or how they will attack an application of stay if their side has won. So I'd request that you allow me to give my ruling, and we leave it at that. Thank you. So this is my ruling on the oral application. The court has heard and considered the petitioner's application for status quo or stay or interim relief that would maintain the petitioner as the governor of Meru County and stop the consequent actions that the judgment of this court has allowed to take place from being implemented. Learned counsel for the petitioner has argued that the temporary relief Learned counsel for the petitioner has argued that the temporary relief, in whatever form, would allow the petitioner to adequately canvass the pending Meru High Court matter, which in the judgment of this court, a number of issues have been reserved for hearing and determination by that court. Further, Counsel Mutuma submitted that doing so would also allow the petitioner to effectively apply for and exercise her right to appeal to the court above. Counsel Mutuma argues that no party would suffer any prejudice, as in essence, the oral application, if granted, would merely maintain and extend the status quo that has obtained from 21st August 2024 for a few more weeks and months. Learned counsel underscored that, on the contrary, not allowing the oral application would result in significant changes in the governance of the county of Meru and would render the Meru High Court matter or any forthcoming appeal academic. In support, learned counsel for the first interested party, Counsel Lawi, on behalf of all the interested parties supporting the amended petition, echoed the submissions of petitioner's counsel and reinforced the need for a status quo order to allow for a seamless appeal process as well as a seamless hearing and determination of the other matter. Counsel Thanji, learned counsel for the respondent, opposed the oral application. She observed that the court is now functus official and the petitioner has other avenues in a matter that is still pending, being the Meru High Court matter, or upon appeal. She concluded by noting that the judgment was clear that the Senate's actions and resolution were constitutional, and thus it would not be proper to suspend that action, and also this own court's judgment delivered earlier in today's session. Counsel Kirimi, learned counsel for the third interested party, and on behalf of all counsel for the interested parties opposed, added and argued that this court cannot stay a negative finding, and the granting of the oral application would amount to this court sitting on appeal of its own decision. Counsel Kirimi argued that stay or interim relief would greatly prejudice the people of Meru, one of which he represents in these proceedings, who have been eagerly awaiting the conclusion of this matter. The grant of the orders sought orally would also prolong the uncertainty in Meru County. He rested by arguing that in any case, it is a weighty application that should be in writing, with all parties being granted time to respond before a decision. I have considered the submissions by learned counsel and reflected on the matter in light of the unique circumstances of the case and the applicable judicial precedent. And I find that this court is not the appropriate forum for consideration of the grant of stay or the grounds adduced by learned counsel for the petition. Counsel explicitly referenced other fora that are, to my mind, better placed to consider and apply the injunctive relief sought on the basis of cases filed and pending before them or to be filed before them. I'm also satisfied that the Constitution and statute law provide for subsequent processes that would address any governance challenges that would arise from the operationalization of this judgment delivered a few moments ago. Lastly, I find that neither the petitioner nor the interested parties in support have identified any weighty issue that would or could be a potential error in my judgment just delivered that could form the basis of this court considering if there would be an arguable appeal or a just reason to stay this judgment in the interim. Overall, and noting that our constitutional order gives the petitioner ample time to seek injunctive relief in other fora, and noting that this has been a prolonged litigation in which the petitioner has enjoyed interim relief since 21st August 2024 with respect to a resolution of the Senate that has been found to be lawful by this court, I decline to grant the interim relief or stay sought orally. Certified copy of judgment and proceedings to be availed on priority. 14th March 2025. So I will work on the slight. Yes, Ms. Tanch, sorry. No.
Sorry, thank you, my lord.
Yes.
We appreciate the industry and the time taken for everything.
Councillor Mutuma?
Yes, sir. Thank you, Your Lordship, again for the industry. For your time and ruling. We abide by this.
Thank you, Council. I will. The only minor errors. Sometimes when you read in your mind, you don't catch these errors. You can only catch them when you read out loud. They're very minor, so you'll have this very shortly. Also, there will be a press release that will be communicated. I don't know why my court assistant has looked at me. My court assistant will get the press release, and it will be communicated through the appropriate judicial channels to the media. Before I rise, I'd like to sincerely thank Council on all sides for the manner in which you have argued your respective positions. I have been greatly impressed by the depth of your submissions. And even as a judge, I can safely say that I have learned things from reading your submissions and the manner in which you argued your respective cases. I look forward to seeing you all in future matters. Thank you. Have a good day.